Hello, doctors, and I'm Dr. Chris Rapoff of EZ QME Continuing Education, and welcome to this week's case law update. Today I bring you a pretty interesting case that you may be actually surprised by the outcome. In this Adams versus Mr. Plastics, the defendant sought reconsideration of the workers' compensation judge's decision. The defendant alleged that the workers' compensation judge erred in finding that Mr. Adams actually suffered an industrial injury that caused him temporary disability. The dispute in this case involves AOE, COE, which is no surprise, but I'm going to let you be the judge here. Once provided the facts in this case, you tell me, do you agree with the ruling? Let's take a look. Now here we have a case where, as I had mentioned, the defendant is disputing the workers' compensation judge's ruling in 2023 and their findings and award order, where the judge had concluded that the applicant, while he was employed with Mr. Plastics as a machine operator, on May 13th of 2019, he sustained an injury arising out of and in the course of employment to his right hand and causing temporary disability from May 14th of 2019, the day after the injury, that continued indefinitely and required the need for further medical care. Now, the defense argues that, number one, Mr. Adams didn't meet his burden of proving the injury. Number two, the medical records did not support a finding of an injury at work on May 13th of 2019. And number three, there was no basis for temporary disability, since, in their opinion, there was no injury. During his court hearing, Mr. Adams was the only witness, and he stated that he injured his thumb on May 13th of 2019 while programming machines and running parts into a machine. He was working with a long board that required 3 vices to secure them. One of the vices got stuck, so he had to use his right fist to hit the board from underneath in an effort to get it from sticking. He did this 3 times, and on the 3rd time he began to feel pain at the base of his right thumb on top of the closed fist. He stated that the next day he sought treatment at Kaiser and was diagnosed with a scaphoid fracture. Now this is where it gets interesting. During the testimony, he mention that he had a home injury on May 12, 2019, one day before his work injury. And he stated that while he was at home, he was moving an extension ladder and tried to close the ladder when the rungs of the ladder closed on his right hand, catching his hand between the rungs. He continued to work at home as he was trimming shrubs on a 12-foot fence with a hedge trimmer. Now let's jump forward to his visit to Kaiser after his work injury. The day that he presented to Kaiser on the day after his work-related injury, to remind you, it was May 14th of 2019, Mr. Adams was given a splint for his right thumb and then given a permanent cast 1 week later. He reported to work a couple of days later, but realized that he couldn't work due to the cast. Then Mr. Adams was informed, and he actually received a notice of layoff 2 weeks after this injury at the end of May. So during his testimony, Mr. Adams thinks he must have told someone at work of the injury, but he was not sure. So during his testimony, the cross-examination by the defense occurred, and as I had mentioned, Mr. Adams said that he reported the work injury to the Kaiser doctor, as he said he thought he did, but he wasn't certain that he did. He also said that he recalled initially that he was told that he didn't have a fracture of his scaphoid. Also, he tried to return to work on May 17th of 19, but he didn't remember if he had a removable splint or a hard cast. And finally, he doesn't recall telling the Kaiser medical doctor of the right hand injury with the ladder at home the day before the industrial injury. So as you can see, there are quite a few questions here that arise. And the defense continued in the cross-examination, and Mr. Adams did not recall, and when actually he was provided medical records. And the medical records indicated he was treated for a right thumb pain and had x-rays of his right thumb taken in 2014, 5 years before this injury, and that showed degenerative changes in his right thumb. So keep this in mind, 5 years prior, and there are a number of questions here that are posed by the defense. Additionally, Mr. Adams didn't recall that when his last treatment a Kaiser was, and if there was ever a diagnosis of a scaphoid fracture. Finally, he couldn't recall telling his supervisor at Mr. Plastics of the injury or sitting for a deposition after the injury. I'm sure you're thinking what I was thinking when I initially read this. The defendant must be jumping for joy because of the lack of credibility in this individual. But then Mr. Adams did tell us something that was very important in his case. He stated that he was assaulted by a neighbor in October of 2020, which was 17 months after the alleged industrial injury. And this assault by his neighbor resulted in Mr. Adams having a short-term memory problems, loss of sense and smell, and balance issues. However, his right hand, as he recalls, was not involved in the assault. I'm sure you have the same questions I do. What in the world would the workers' compensation judge and the appeals judge consider? How would they resolve this issue? First of all, there was a lack of references in the medical records of the work injury itself, the one that was dated May 14th of 2019. The only reference in the medical records in May of 2019 were for the non-industrial right hand injury involving closing the ladder on his hand the day before the industrial injury. And this happened at home. And finally, there were no references to the work injury until after he filed a claim in June of 19, 1 month later, after he was laid off from Mr. Plastics. How did the judge handle this? How did they tackle the number of questions and the inconsistencies in the testimony? Well, they turned to the QME report, and this is a very important case here because it does establish the importance of a well thought out, convincing QME report. In this case, they determined that the reference by the QME documented a right scaphoid fracture and a record in May mentioning a right scaphoid fracture was one of the determining factors as well. If you recall, Mr. Adams did not even remember whether or not he had a fracture. Also, the QME confirmed the mechanism of injury to be consistent with Mr. Adams' version of his work injury on May 13th of 2019. And finally, the QME indicated the home ladder injury the day before his industrial injury was to a totally different area of the hand and not near the scaphoid bone. Now, as you recall, Mr. Adams was unable to provide any additional information for either one of the home injury or the work injury, so the judges relied on the QME's report for clarification. So how did the workers' compensation judge and the appeals judge, what conclusions were they able to arrive at with the information was provided? Well, number one, without the QME's opinion and the May 19th record that there was an actual injury to Mr. Adams' hand, the opinion might have been different. Also, Mr. Adams' memory and his credibility was an issue, but in spite of him suffering memory loss, his account of the work injury was consistent with the records that regarded the fracture and the mechanism of injury during the work-related injury. And finally, with regard to temporary disability, the judges disagreed with the defendant that there was no basis for temporary disability because they stated that the QME provided a work restriction in his report of no right hand use, as the defendant provided no evidence that Mr. Plastics could have accommodated that restriction. So on the basis of all of these, the reconsideration for the ruling was denied. So there are some things to consider here when you read this case and give thought to cases that you have had and possibly that you'll consider in the future. First, the medical records didn't specifically state a work-related incident. Also, Mr. Adams' loss of recollection of many of the pertinent facts and details when he testified before the workers' compensation judge, in my opinion, was pretty important. However, more importantly, the importance of a thorough, well thought out QME report that is accurate was provided by this QME, and that seemed to be the determining factor for both the workers' compensation judge and the appeals judge in denying this reconsideration ruling. So my question to you is what would you conclude if you were the judges here? So once again, doctors, I hope you enjoyed this presentation that stresses again the importance of a QME's opinion being accurate and thorough. Here, this QME's opinions and conclusions were virtually the sole basis of the judge's ruling. And this is just another example of the good work that we as QMEs are doing and trying to do as we strive to provide the best, most accurate QME reports in the industry. I'm Dr. Chris Rapoff, and I wanted to thank you for taking the time to join me today in this presentation. I hope you enjoyed it, and I look forward again to sharing some other interesting cases with you soon. Thank you.